the founders of Gentrio, and I'm also an attorney with over 20 years of experience in estate planning. So right now, as we all know, this is a unique time in our history wherein we're all social distancing and taking care of ourselves to this COVID-19 pandemic. One of the things that we have to do is prepare for our future legally by having the appropriate estate planning documents in place. So by watching this webinar, you've taken the first proactive step to protect yourself and your family, so you have an understanding of what you need in order to protect your choices, your loved ones, and your assets. So what would be the critical documents that everyone should have right now for their estate plan? I would say there are 4 things, possibly 5. The first is a healthcare proxy. This is a document in which you can designate someone to make decisions for you in regards to your health or your personal care needs. A financial power of attorney is another document in which you appoint someone to take care of your finances, manage your estate. Third document that's critical for your estate plan is a will. Most people have worked hard all their lives and care about where their hard-earned assets go. They want to benefit the people they love, not people that they've had fractured relationships with or conflict. More importantly, for those of us who are parents of minor children, we want to nominate someone who we would want to take care of our children and not leave it up to a stranger to decide. Another document is a pet power of attorney. This is a document, if you're a pet owner, in which you enable someone to make decisions in regards to your pet. It protects you, your pet, your veterinarian, and your pet sitter. Lastly is a trust. Now, not everyone would need a trust, but it is an estate planning tool that would enable you to protect your assets and also, again, state where you would want your assets to go to. More than having the documents, as I said, I'm an attorney who's been in practice for a long time. The other critical piece is having access to the documents. I cannot tell you how many heartbreaking court cases I've been involved in which family members know their loved one wrote down their wishes, but they can't locate it. So it's a 2-part process. You have to create the essential documents that you need, and then you have to store them in a manner in which they could be accessible in the event of an emergency, and accessible by someone that you know, you love, and you trust. That's one of the positives of the Gentrio product, because we offer as part of all, wherein you're able to store your documents online and share them with whoever you want. So right now, it's very challenging. In Massachusetts, the courts are shut down until at least June. And undoubtedly, it may extend due to this pandemic. In the best of times, it's difficult to get emergency orders. Not that the court's not diligent and serious about matters that require emergency hearings. It's just the nature of the beast. Instead of having a document in which you're appointed to make someone's decisions for them, you have to go to the court and fill out a bunch of paperwork, your pleadings, showing why you need to be appointed to make a healthcare or financial decision on behalf of someone else who may be sick or incapacitated. And what's a heartache about that is that at a time when you'd rather be with your loved one, you're at court and you're having an added emotional burden in addition to a financial cost. And further, it's putting you in a situation in which you're relying on others, on attorneys, on the bureaucracy of the court, and on a judge to make a decision that you know your loved one would want. It's much easier if you or your loved one had prepared the documents ahead of time to avoid all those problems. What's very important is that as a family member, you need to take care of yourself, but you also want to make sure your adult children have their documents, or your brothers and sisters, or if you have elderly parents. Everyone needs to have their estate planning documents. Especially right now, I think we've all learned that it's important not to procrastinate. I think for most of us, we get caught up in the day-to-day. We're very busy trying to, get through the day, get everything done we need to do. The upside to the pandemic and being forced to stay at home is that we can get off of our list many of the things that we haven't had time to. I know many are probably doing their spring cleaning, cleaning out drawers, closets, looking at clothes, etc. This action, meaning creating your estate planning documents, or if you've already created them, reviewing them to make sure they still are what you want given your current circumstances, is really much more important than doing that other type of spring cleaning. This is an opportunity to take the action that you need to protect yourself, your health choices, and your loved ones. So let's dive deep into the 5 estate planning documents that I've already mentioned. The first one is the healthcare proxy, otherwise known, depending upon your state, as a healthcare surrogate, a power of attorney for healthcare. With a healthcare proxy, there are other components that would be a living will, which is what you want for end-of-life planning, and other types of advanced directives. An advanced directive is simply telling your proxy, your agent, what you would want to do in a given circumstance. Gentrio's healthcare proxy offers all that and more. Let's walk through it. A Gentrio healthcare proxy gives you the opportunity to name who you would want to be your first, second, and third choice as your healthcare agent. This would be the order of people that you would choose to make your healthcare and medical decisions for you if you were in a situation where you were not able to do that. None of us have to imagine that as a foreign experience right now, sadly, given the COVID-19 pandemic. Many of us have friends and family that are sick. Some are in hospital, some are on respirator. When you're on a respirator, you're not able to communicate what you want. So you really want to have an advocate for you, your chosen agent, to make those decisions. In addition to nominating a healthcare proxy or agent, a Gentrio healthcare proxy has a HIPAA authorization. That's the authorization in which your agent can freely communicate and review your medical records, make the best decision for you in your given circumstance. Obviously, this requires a high level of trust. So it's very important that the person that you choose to make these decisions for you in the event you're not able to is someone that knows you, knows your values, who's trustworthy, and can also advocate for you. Remember, not everyone is going to want you to be cared for in the same way. There may be conflict. So you need to be able to pick someone who's strong enough to advocate for you and what your wishes would be. The healthcare proxy also includes an option to say what you would want for end-of-life planning. This is an opportunity to say, do you want to be resuscitated? Or do you want a DNR order? A DNR is a do not resuscitate. These options are so that you can tell your agent and you can expressly put in writing what it is that you want. Also, there's the opportunity of saying what type of life-sustaining treatment you would want. And all this is very fact-sensitive depending upon your values and your wishes. Life-sustaining treatment could include artificial hydration and nutrition. It could also include dialysis. There are many things. Some people, especially when they're older, may choose, I would rather have a higher quality of life and not be dependent upon other things. And they would express that in their healthcare proxy. Other people who are younger may choose to have most extraordinary measures taken to keep them alive. Again, it depends upon your particular circumstances. The beauty of all this is it's your choice. And by taking the opportunity to completely fill out a healthcare proxy, you are expressing what you want and enabling and empowering your agent to make these decisions for you. A Gentrio healthcare proxy also gives you an opportunity to state whether or not you'd like to be an organ donor, and gives you an opportunity to say what you definitely want and what you definitely do not want. Explicit instructions or prohibitions. It's up to you what you want to put in it to tell your agent. Some people, and I would say in fact most, don't like to tie their agent's hands because everything is so fact sensitive and the medical community is developing things all the time that they don't want to tie their agent's hands. So they basically say, I choose you, I trust you, I know you'll make the best decision for me. That is a healthcare proxy. A financial power of attorney, similar to a healthcare proxy, is a document in which you appoint your first, your second, and your third choice to make financial decisions for you. Now, a lot of people get turned off by the idea of estate planning and say, oh, I don't have an estate. You know, I only have $100,000 or something like this. We all have an estate. If you're a capable adult, you should have these two documents, a healthcare proxy and a power of attorney. No one knows what the future can bring, and you need to be prepared, and you want to make it as easy as possible for your loved ones to take care of you. Again, you don't want them spending valuable money and, more importantly, time in court to get the authority to make decisions for you. A financial power of attorney, as I said, is in control of finances, your assets, and your debts. Within a Gentrio financial power of attorney, you have the possibility of saying when you want the power of attorney to start and when you want it to end. Or you could make it durable, meaning it would go on forever unless and until you revoked it and chose someone else. Additionally, you're able within a Gentrio power of attorney to choose exactly what authority you want to give your agent. You may only want to give them limited authority, maybe only over your bank accounts, but not your investments or other things, or your trust or your will or whatever. But that is your choice, and you're able to simply walk through the slide survey and make decisions as to how you want to empower and authorize your power of attorney. The third critical estate planning document is your will. This is the document that only kicks in after you die. This document expresses your wishes for where you want your assets to go and who you want to benefit. It also enables you to choose, again, if you're a parent of a minor child, who you want to be guardians of your children. And finally, it allows you to nominate someone to make these decisions for you. The personal representative. This is the person who would uphold your wishes as expressed in your will and make sure that they're carried out. So the first two documents that we talked about, the healthcare proxy and the financial power of attorney, are documents that are in effect while you are alive, but can't make those decisions. There's something that's made you unable to communicate or express your decisions. The will is only in effect after you die. A pet power of attorney is a document similar to the financial power of attorney and healthcare proxy, in which you nominate someone to make decisions for you in regards to your pets. Now, of course, right now, many of us are not traveling due to the COVID-19 pandemic. However, absent that, when things get back to normal and we are able to travel, many of us are dependent upon pet sitters to take care of our animals. And usually, if there's nothing serious going on, a note on the refrigerator works. However, again, what we're in the business of is planning, preparing, protecting. We don't know that nothing will happen. So accordingly, we want to have all of our bases covered. And that's why you would do a pet power of attorney. Within that document, you can say what authority you want to give your pet agent. Are they able to bring your pet to the vet and agree to an emergency surgery? One of the critical components of this is setting a financial limit. Not all of us would be able to afford a $20,000 emergency surgery for our beloved pet. We need to, and your pet sitter in all likelihood does not know your financial status or your bank account. Accordingly, if you express that clearly in this pet power of attorney, the pet sitter has guidance as to how much you can afford and can make the best decision possible for your pet and you in that given circumstance. This pet power of attorney also protects your vet. There are times when a vet does not want to make any emergency decisions without having direct contact with the pet owner. We've had numerous cases reported to us at Gentrio, and one was an awful circumstance in which a soldier serving us overseas in Afghanistan, his girlfriend was not empowered to make an emergency surgery decision on behalf of the dog, his beloved dog, because she didn't have any authority. So they had to track him down overseas. It was 48 hours later, and ultimately he agreed to the surgery. But in the meantime, the dog's life was more at risk. The girlfriend was so upset and distraught, as you can imagine. Her loved one's overseas, his dog is with her, and the dog had a serious stomach issue. Nonetheless, this was a happy outcome because they were able to get in touch with the soldier and got the permission, and the dog was saved. But all that 48-hour of stress on everyone could have been avoided if there was a pet power of attorney. Finally, another estate planning tool that not everyone needs, but certainly it is an option in terms of managing your assets and providing for your loved ones, is a living trust. This is a document in which you have an opportunity to place items that you personally own in a trust that you have created. So now you don't own the items, the trust owns the items. And the trust is usually set up with a series of beneficiaries, usually benefiting you first, and then others that you choose. In addition to creating the trust and establishing the trust, other people involved in the trust are the trustee, that's the person that manages the trust, and the beneficiaries. Those are the people that benefit. And usually with a living trust, there's tiered beneficiaries, meaning that you be your first beneficiary of the trust, but then at a time later on, usually upon your death, you have other beneficiaries that would take from the trust, and the trust would wind down. Now, the advantages to this are that you would not have to go to court. The trustee can, in most cases, act without any court authority because they're empowered by the trust document. This would change if there was litigation. However, in most cases, that's not what happens, and the trustee seamlessly takes care of the beneficiaries and the trust is dissolved. Sometimes the problem with the trust is that it's never 100% fully funded with your assets. In fact, most often it's not. So that in addition to having a living trust, you have to have what's known as a pour over will. And when I say pour over, P-O-U-R, this is a will in which you make your trust the beneficiary of whatever is left in your estate that you haven't already put in your trust. So these are the critical estate planning documents that we here at Gentrio would encourage people to create in order to protect their choices and their loved ones. And during this time, we really want you to prepare. So this is the dark side of it, right? If you have no estate planning done, what happens? And it's not a pretty picture. I think most of us have families in which there is some tension and some conflict, and when there's crisis, things blow up even more. Not to say that there's not some families that can get their act together and work together, but in most cases, we're all human, We all have human frailties. It doesn't work that way, and it causes conflict. So what happens is, with absent authority, doctors can't make decisions for you. They need a decision maker. And if you're incapacitated and you don't have a healthcare proxy, more often than not, the hospital or your loved ones are forced to petition for what's known as guardianship. This is a court action in which you get someone to have authority over you. The particular downside of this is if you have a situation in which your family is in conflict, more often than not, the court will not appoint any loved one or any family member. The court will appoint a neutral third party, because the court, in its wisdom, can't decide between Team A and Team B. They're going to appoint someone that they know and trust, an attorney more than likely, who will make these decisions for you. So that's like the worst possible situation. You don't want a stranger making those decisions for you. That's the same on the financial side. The action that's taken in court is a conservatorship. You get a conservator appointed for you to manage your money. And again, if there's family conflict and there's a stranger appointed, these are people that have no idea of your wishes and your values. So it's really a situation that no one wants. And it can be easily avoided by creating your estate planning documents. So at the beginning of our webinar here, beyond creating your documents, it's really important that they are stored in a place where someone can easily access them. I'll give you an example that I've seen more often than I would like. People diligently come to an attorney, create their power of attorney, and say, oh, I'm going to put it in a safe place. What is that safe place? A bank safe deposit box. Now, they will tell their agent, oh, I've named you my power of attorney. My power of attorney is in the safe deposit box. How is that agent going to access your safe deposit box when they don't have your power of attorney because it's in the safe deposit box? So what happens is your poor agent now has to go to court to get authority to be a conservator, to open up your safe deposit box to get the power of attorney. And at that point, in a sense, your power of attorney is moot because they've already had to go through all the hoops to get you appointed conservator. No one wants this. We've had other situations reported to us at Gentrio where parents have put all their relevant paperwork in a gym bag, have put it in a shoebox under their bed. That doesn't work, particularly in this day and age where most American families do not live in the same city and state. We'll have people that live in Massachusetts and their parents live in Pennsylvania, and their college students is in California, and their other adult daughter is in Washington State. Having all your documents hidden under your bed or in a duffel bag is not going to be easily accessible for when a crisis hits. Accordingly, and one of the beauties of the features of Gentrio is the Gentrio Family Vault. You're able to store all your estate planning documents that you've created, as well as all other important documents to you. So in other words, say you nominate Michael to be your power of attorney. You can give, through your Gentrio Family Vault, access to Michael to your power of attorney. So he could simply go onto his phone, click on it, and get it anywhere, anytime. But you could also give him, I do my banking at XYZ Bank. I have securities with ABC Financial Advisor, etc. By providing him access to that information, he would be able to quickly and easily manage your money. Similarly, with the healthcare proxy, which of course during this time is very critical, you could provide all your health information. This is my primary care physicians group. This is my specialist. These are the medications that I'm on. These are all the people that if something happens to me, I want to be notified. All that information, if it's stored in a place like the Gentrio Family Vault that's easily access and shareable, you're making it so much easier on the person that you've appointed to make these decisions for you. You're making it easy for them to do their job. So thank you so much for coming to our Gentrio webinar on estate planning. I hope as you've heard this brief outline of the critical documents that you'll take this opportunity to talk to your loved ones and have everyone create their estate planning documents. Right now we'll go to some questions. Thank you. How old should I be when I set up these documents? Oh, that's an excellent question. Depending upon your state, but I would say 18 on average is when you should begin to create these documents, especially, again, the healthcare proxy and the financial power of attorney. And if you're young and you've already have significant wealth or whatever, good for you, and do your will also. And obviously, if you have a pet power of attorney, do that. But basically, every adult American who has capacity, they should do this. How long does it take to complete each of these forms? Trust, healthcare, proxy, will, etc. So with the Gentrio online solution, it can take as little or as much time as you want. I would say it probably takes 10 to 15 minutes to complete each document. The reason why I say it depends upon you is there are some things that may take longer for you to decide. It's not that it's difficult to complete the slide survey. In fact, it's very easy. However, you may be torn about, well, who do I really want to take care of my children if I'm not able to, and what that order is. And you may be thinking, oh, well, I have someone that I really trust to make healthcare decisions for me, but she's really not strong enough to fight doctors. So all these factors would lead into how long it would take you to complete it. But the survey itself is very, very simple and easy, and you could complete all of them within an hour. Does a power of attorney work after you pass away? No, it does not. The authority of a power of attorney, a healthcare agent, and a pet power of attorney, all that authority dies when you die. Usually what happens is there's a gap of authority in that it takes time for your will to be probated or your trust to be managed. So there can sometimes be a little bit of a gap. And for most things, it doesn't matter. But your power of attorney, healthcare proxy, and pet power of attorney have no authority once you pass away. Can I complete these forms on my own, or should I complete them with my husband? Oh, that's another great question. Most couples work together and come up with a joint plan. At the same time, no surprise, there may be conflict, right? I might want my brother and my husband might want his sister as guardian. So when you join Gentrio, you complete these forms on your own with your own account, but you're able to say your choices about what you want. And similarly, your spouse can make his choices about what he wants. So there may be some offline discussions in which you say who you're choosing, who you're, you know, who your choices. So it doesn't seem like we have any other questions. Again, thank you so much. And if you think of something, I'm sorry, there is one. Will video and information be made available after the webinar? This will be, thank you for this question. This webinar will be posted on our YouTube channel, and you can go there, Gentrio, and you can see it. And also our website has a lot of educational material that discusses even further the topics that I've spoken about today. And while you're reviewing our website and our YouTube site, you can email us at info@Gentrio. We're not a firm. We can't specifically legal advice, but again, we can show what you need to do, the critical planning documents that would protect you and your loved ones. Property classes, what should the surviving member do? So it really depends upon the terms of a trust. A trust that's held, property that's held in trust, if it's real estate or whatever, and the trust owns it, the person who sets it up, as I said, a living trust is the primary benefit. There's usually, after the seller, who's the person who created it, and the first spouse, depending, the terms of the trust are set up that if it's real property, that it's sold and distributed, or it could be saved for the benefit of future generations of the family. People sometimes do this with vacation homes to benefit future generations. But there is no hard and fast answer here, because it really depends upon the terms of the trust that you created. Well, I guess that was our last question. Thank you so much again for taking the opportunity to join me here today and learn about estate planning. I hope that you understand the importance of it, and will talk to your family members so that everyone will have the necessary documents to protect their choices and their assets. Thank you.